First District Court of Appeals now in session. All who have business before this court draw near, give attention, and shall be heard. May God save these United States, great state of Florida, and this honorable court.
Good morning. Welcome to the First District Court of Appeal. We have one case before us on this Zoom OA. It is West Shore Legacy LLC versus Alachua County and Fickling and Company. And the case number is 210986. Ms. Giddings, you may proceed when ready.
Thank you, Your Honor. Good morning, Your Honors. I'm Kathy Giddings, and I'm here on behalf of West Shore, and I would like to reserve 4 minutes for rebuttal. Also, Your Honors, there are 3 issues in our briefs, but unless this court has questions about issue 3, I'd like to focus today on issues 1 and 2, which is the school capacity. I would also like to tell you that even though you have a lot of information in front of you, a 10,000-page record, I think I can actually make this pretty simple for you if you understand 3 things, which are imperative, especially for the school issue. The first is that there are 2 stages in land development. The first is the plan amendment stage, and that's where you come in and you change the use here from institutional to a traditional development. The second stage is later, and that's after the amendment has taken place. The contractor, the developer, they come in and they have a site plan. That's a totally different process. And for schools, element 1 governs the first stage where we are now. Element 2 governs the site plan stage, that later stage. And then the third thing that I think it's important for you to understand is Alachua County has adopted not to have school zone district-wide. It has what it calls concurrency service areas. And so there are lots of different service areas that overlap because you have different service areas for elementary schools, middle schools, and high schools. And of course, that makes sense because you have a lot of elementary schools, you have fewer middle schools, and you have even fewer high schools. So these service areas overlap.
Can I interrupt you? I understand the county wasn't per the plan to consider the adjacent schools, but why can't it consider capacity district-wide?
Well, Your Honors, because if you look at 1.1.3, it says in determining capacity at this amendment stage that you have to look at the relationship of these districts, these service areas as they overlap as a whole, and on the applicable service areas. But for purposes of school capacity planning at the plan amendment stage, existing or planned capacity in adjacent service areas shall not be considered. Now, the ALJ and the county said they could be, but if you look at the statutes, and in fact, the statute that they cited themselves, if you look at 631.3180, 6B2, it actually says if you've adopted these service areas, that at that site plan development stage, that second stage, you can look at adjacent service areas, but you cannot do it now at the amendment stage. And why is this important? Because for planning, you have to know if there's not capacity. Everybody admits there's not capacity in the assigned service area, that if you have to give recommendations, and not just recommendations for remedying the capacity in a particular service area, but also what it's going to cost, and you have to send that to the municipalities. And there are 9 municipalities in Alachua County, and it may cause rezoning, it may cause, it's going to have everything to do with planning now. So when you're talking about amending this property, you have to know the county, if it had these statistics and it knows that there's not capacity, it might, in agreement with the municipalities and the school board, it might still agree to go forward, but you have to have, the school board has to tell you how much that's going to cost. And so for that reason, this is not in compliance.
But the policy, doesn't it say that the capacity only has to exist before the final development order can enter? And we're not to that stage yet. So given that they've considered capacity, although you might disagree with it, how is that an error then?
Your Honor, it's the statutes require that comp plans be applied consistently, and you have to apply the plain language of the plain language of the comp plan. And at this stage, the plain language of the comp plan says you cannot consider capacity outside the assigned service areas. And here, the assigned service area, the county has conceded that they do not have capacity in the assigned service areas. There's only capacity in other service areas. So this is expressly prohibited by the comp plan. And frankly, I think that the person that testified on behalf of the school board who said how they do this, I think she was actually confused between this stage and the second stage. And, you know, that makes sense because she actually did a letter with the report early on. And then later, she acknowledged that she had done that determination wrong and had to change all the numbers. It didn't change her ultimate recommendation that there was capacity district-wide. But at this amendment stage, under a de novo review, there's no other way to read this language. You cannot look outside the adjacent, you cannot look outside these service areas for existing or planned capacity.
Can I ask you a question? I'm sorry.
No, go ahead, Judge Ray, sorry.
What does that policy provision mean when it says that the school system as a whole should be considered?
Your Honors, you know, when I first looked at it, because I said, well, it's saying that you cannot look at these adjacent service areas, but you have to look at it as a whole. The only way to read that is that these service areas overlap. So, you know, you've only got a few service areas. The service areas are actually in the record, and you can look at those, but you have to look at those as a whole because they overlap. And so that's what you're looking at, the impact, and whether you're going to have to rezone this area later as part of the recommendation for changing and having capacity. And it's interesting because if you do look at the section that I cited in 631.3180, it actually says that you cannot send students to the adjacent service area absent rezoning, even if there is capacity there. So that's why it's so important to do it now. And, you know, the municipalities, I mean, this is an unincorporated area, but the municipalities have their own comp plans, their own rezoning. And so that's why they have zoning for schools. So that's why it's important for everybody to work together. And, you know, the county itself is the one that adopted this comp plan and said that you cannot, in looking at existing or planned capacities, look in the adjacent service areas. Your Honor, you're on mute.
Sorry. Yeah. Can I ask you about the traffic before we run out of your time?
Yes, sir. Absolutely.
Ms. Brighton's testimony, why wasn't that competent substantial evidence with regard to the available traffic capacity?
Your Honor, we're not going on competent substantial evidence. We're going on an issue of law. And under the traffic, under 1.1.4, the measure of service is to be measured by a professionally accepted traffic analysis. And they didn't, and in 1.1.611, it requires that the applicant provide one of these, and they did not. Now, what the county said and what the intervener said was that that is a guideline. It's not required. But if that's the case, then why does it say that the county shall require the applicant to provide that analysis? So the county, all that the applicant did was provide a trip generation of the number of trips. And if you look at the comments that were submitted, traffic was the overwhelming concern. When I first started looking at this, I looked at, you know, what is level of service D? Well, apparently level of service F is just horrible traffic. And some of the intersections on Fort Clark Boulevard are in fact a level F, but you do look at it district-wide. That's understandable. But the county, instead of requiring a traffic analysis, it just went and got data that it had from several years prior and said, oh, well, there's capacity. Well, if they had required the applicant to provide this analysis as required by the comp plan, then they would have had more current data and they could have given a more accurate report. So again, the law is clear that a plan has to be in compliance. It has to be applied consistently. And that is not what occurred in this case. And so as a matter of law, in reviewing the plain language of the comprehensive plan, we believe that that the plan is not in compliance. Your Honor, if there are no further questions, then I'll save the rest of my time for rebuttal.
All right, my understanding is that Mr. Hansen's going to go, y'all are going to split argument?
Yes, Your Honor.
And you're going first?
Yes, Your Honor.
Okay, y'all need to be responsible for figuring out who does what when then. So go ahead.
Thank you, Your Honor. May it please the court. Good morning. My name is Corbin Hansen, representing Alachua County. At the outset, it's just a general context. This matter involves a challenge to an amendment to the Alachua County Comprehensive Plan, which is done as part of the county's legislative capacity. It's a policymaking decision, and it allows the local government to be flexible in planning for future development in the appropriate areas to ensure that the local government has the necessary resources to efficiently utilize them and to ensure that the members of Alachua County, the citizens of Alachua County, have access to things such as a functional transportation network and school facilities. And in the instant case, we have a situation where after 3 public hearings, after a review by the agency on an intermediary basis, all different levels found that the plan amendment was in compliance with the statute. The appellant then appealed or challenged it to the Division of Administrative Hearings, where the administrative law judge found that the appellant failed to satisfy its burden in the case, often providing no relevant evidence for the claims made during the hearing regarding school capacity, traffic capacity, and compatibility with the neighborhood. After filing numerous exceptions with the recommended order, the agency once again found that the appellant had failed to meet its burden, which was on them.
Counsel, I'm sorry. Since we know a lot about the background of this case already, I want to ask you about one of the appellant's arguments related to school capacity. And that is the argument that the school board erred by considering the capacity of the adjacent SCSAs as a part of its capacity assessment. And that certainly seems to be prohibited by policy 1.13. Can you respond to that?
Yes, Your Honor. I think it's important to understand what the intent behind policy 1.1.3 is. And as appellant's witness below, Suzanne Wynn, testified, the only witness regarding school capacity, 1.1.3 is utilized as a planning tool. It initiates that conversation, that dialogue between Alachua County and the school board of Alachua County to determine what capacity is currently, and also to put the school board on notice of what plans are in the pipeline and what will be coming to them. There is a student generation calculator. There's a calculation that's used to determine at a maximum number of units, how many students would that create? And all of that is intended so that when the school board goes back to evaluate their own current facilities and their future plans, that they know what might be coming down the pipeline. It is not a concurrency evaluation, as Ms. Giddings pointed out. There is the capacity and then there's the concurrency. This deals at the capacity level strictly with the hypothetical what might happen so that the school board knows what's coming. And that's why when you look at the full language of 1.1.3, it says that the school board will perform an analysis on the school system as a whole and on the applicable school concurrency service area, which is what happened here when Ms. Wynn looked at both the capacity in the Fort Clark middle school concurrency service area, and also the capacity on the adjacent school concurrency service areas. So when you think about it as what does that language mean? I believe that was your question earlier. That language is intended to provide that tool for both the county and the school board to coordinate their planning efforts.
I'm sorry, go ahead.
I apologize.
I was going to ask you about the traffic analysis, if you're going to talk on that, or is that for Ms. Boyes?
I can speak on that as well, Your Honor.
Okay. The traffic analysis, was that a sufficient professionally accepted traffic analysis? I know that Miss Brighton talked about doing that, but was that enough, what she did?
Your Honor, it's also important to, in this situation, understand the context that we were in at the time of adoption as well. The county has to perform every 7 years an evaluation and appraisal of its comprehensive plan, which leads to large-scale updates requiring data and analysis to support those updates. That it's called the EAR process. That EAR process was ongoing concurrently with this plan amendment. So when the discussion involved pulling data from 2017 for a plan amendment that was adopted or went through the process in 2019, that 2017 data was applicable to creating the standards that you see in the transportation mobility element that's being applied. So it was not stale that we previously had. It was data that had been compiled and analyzed over the course of years for purposes of the evaluation and appraisal report, which made it applicable to the analysis of district-wide capacity here.
Well, 163.31771F talks about the extent necessary indicated by the data available on the particular subject at the time of adoption. And it was my understanding that Ms. Brighton was talking about data that was 2 or 3 years old. So does that untimeliness cause a problem?
Well, it's important to note that particularly when you're dealing with traffic data, that data does not come in real time. That data takes time to compile, takes time to analyze. And by the time you have a full-fledged report, we're dealing with data that was 1 or 2 years old for a 2019 comprehensive plan amendment that was going on. So that's the most accurate and vetted data that would have been available at that time. Ms. Brighton, in addition to the county's transportation planning manager, also provided more site-specific evaluations of traffic impacts. But the base traffic data was the data that we had already compiled for the EAR update. And just to reiterate a common theme here in this situation for traffic in particular, the burden remains on the appellant at every level of the challenge. And it's important to note that when we went to the administrative hearing, the appellant brought an expert who had never done a traffic analysis in a district without school or without traffic concurrency, who was providing a traffic analysis based on segment by segment capacity. They were not looking at the standards that were currently in Alachua County's comprehensive plan regarding district-wide capacity. And that led to a finding of the administrative law judge that their traffic analysis was wholly irrelevant. And at that point, I think the appellant failed to prove that the amendment was not supported by readily available relevant data and analysis concerning the transportation impacts on Fort Clark Boulevard, or not just on Fort Clark Boulevard, but on a district-wide basis, which is required by the comprehensive plan. And as that was a policy decision by the Board of County Commissioners, if that was something that appellant wanted to object to at the time, they were well aware that the EAR process was ongoing and they could have challenged those EAR updates. However, they did not, which leaves us with the comprehensive plan as it exists today and the county applying those standards that were already adopted.
Mr. Hanson, you've used a little over half your time. If y'all, I don't know how y'all are planning on splitting your time, but I just wanted to let you know.
I appreciate that. Thank you. I will touch briefly on the compatibility arguments. Just it was in our briefs, but generally, the appellants are attempting to compare their 440 plus unit apartment complex and the nearby single family neighborhood with the subject plan amendment, the medium high density residential, and using that as a basis to reject the plan amendment on grounds of incompatibility. The appellant in their brief focuses the court on the maximum 16 units per acre and accompanying non-residential development that would be allowed by the plan amendment without considering the applicable design standards that would mitigate the impacts of such a development, which, as far as this goes, it is a patently unfair have your cake and eat it too situation where the appellant asks this court to cherry pick policies that will increase the potential for impacts between uses while simultaneously ignoring all of the policies and regulations that the county has adopted that would ensure compatibility between the subject property and neighboring properties, even with different uses. And it's important to note, as Ms. Giddings pointed out, there are multiple phases to this process. This is the land use phase. The next phase would be the development, the development phase, where you get into the more specific design criteria. The development does not occur in a vacuum. It's something that the county would have the opportunity to apply design standards to mitigate any alleged impacts that might exist. And once again, appellant has failed to satisfy their burden on each of these contentions regarding compatibility. And if there are no questions, I'll give the rest of my time to Ms. Boyes.
May I please
Go ahead, Ms. Boyes.
Thank you, Your Honor. I just wanted to supplement the argument provided by the county attorney and remind the court that really this case is about West Shore's philosophical disputes with the policies that have been adopted by Alachua County to manage their growth and development within the urban cluster encircling the city of Gainesville, and also philosophical disputes with how concurrency and planning are done in the statutes. I think we can jump to the implications under the schools issue and talk about, well, what happens if Ms. Giddings is right and there's no capacity and we have to stop right now and talk about what to do. She correctly points out that under goal 2 of the public school facilities element, that's where we talk about what does the developer have to do at final development plan. Remember, a comp plan amendment is not a final development order. Thus, we have general planning exercises in schools, transportation, and compatibility to give everybody notice, the developer included, as to what mitigations they might be responsible on down the line when they apply for the specific number of units, specific commercial development on a particular layout. In the instance of schools, we cited this lengthy statute in our brief, the school concurrency statute at 163.3180 sub 6 sub F sub 2 A and B. And in essence, when you get to the end of the run, and let's say the capacity problem at Fort Clark Middle School holds up, and now we know based on the development plan being submitted, X number of units are going to be built, X number of students will be generated. Even if under subsection B of the statute, it's determined that the concurrency service area cannot accommodate the students, the plain language of the statute says, then the local government may not deny an application for site plan or final subdivision approval on the basis of school concurrency. And what happens then is the rest of goal 2 in the school concurrency statute is triggered. The developer is allowed to keep its application alive. They can negotiate to provide land, money. They in essence, under the statute and the comp plan, are allowed to negotiate a formal legally binding agreement. And so this underscores our approach to the case, which is we were at the planning level to discuss general impacts. We are not doing design studies or concurrency studies. Those would be premature. That theme carries directly over into transportation. Ms. Brighton did a trip generation analysis, which is commonly done at the general planning level to give everybody, once again, notice of what's being proposed, the potential impacts, and the developer may decide to scale back their development when they apply for the final development approval. It would be premature and against the statute and the comp plan to quantify exactions for transportation or frankly schools at this very early stage. It's quite possible that, well, in this case in particular, the county has adopted transportation concurrency exception areas, and this property lies within an exception area. The county has rescinded concurrency. What they've done is a state-approved MMTM fund. It's a multimodal transportation mobility fee. This particular applicant would pay about $1 million into the county's coffers, which would then be aggregated with other funds to pay for projects in this transportation district to alleviate congestion. Which brings me to the other major point under transportation. The county's comprehensive plan, in the plain language, in the transportation mobility element, acknowledges and tolerates congestion. It uses the word congestion. It recognizes the intent of these mobility districts is to recognize certain roadways will be congested, and that congestion will be addressed by means other than solely adding capacity for motor vehicles, which in common parlance, road widening. The county has moved away from that. That's a policy decision, as Mr. Hansen indicated, was adopted as a legislative matter. This particular appellant has a philosophical dispute with that, but that's not for this court to decide. This court rules on errors of law, not local policy disputes. And we've cited to the DOA final order, or the agency's final order in the Martin County Company case for that proposition.
Ms. Boyd, you've gotten to the end of your time, so if you can briefly sum up.
Yes, Your Honor. Compatibility, there's a cognitive dissonance in their argument. They suggest that medium land use would theoretically be better for this property. Compliance review does not contemplate choosing the better option. Either medium density or medium high, as this comp plan amendment allows, would allow a super Walmart not relieve their density objections, and they fail to show how those are inconsistent. Accordingly, we
thank you, Ms. Boyd.
Thank you, Your Honor.
Ms. Giddings, you're recognized for rebuttal.
Thank you, Your Honors. A couple of things that I would like to hit on immediately is that you will see that the theme that the appellees have taken is that, oh, this is just the amendment stage. We can do all of this at the site plan. The problem is, once you have designated this particular area, which is sitting there with a church that's been there for 40 years on this 25 acres, the deed is done. The train has left the station because you have said this is what density can be there. So the time for planning is now. In addition, one of the things that Mr. Hansen started his argument off with was, oh, well, you have to look at the intent. No, you have to look at the plain language of what is required. And the ALJ, the department, and the commission somehow were all convinced that they didn't have to follow the plain language. They talked about shall require. Well, that in the traffic, that is, oh, that's a guideline. Well, it can't be if it shall require. The legislature has said that comp plans have the legal status. This court and other courts have not hesitated to find plans in compliance, even after the government and the ALJ and the department have found that they were in compliance, if it is not consistent with the plain language of the comp plan. Here, as to schools, they said, oh, we've got capacity district-wide, and even the statute doesn't allow you to look district-wide. It only allows you to look at adjacent service areas. That's why this says for the planning stage, you can't look at adjacent service areas. And then as to traffic, they talk about, oh, well, the county had this data and they used it, but why else would you require the applicant to provide a professionally accepted traffic analysis? And they didn't do that. And the inquiry should end at the school because they considered district-wide. They conceded there's not capacity. They did not give recommendations to the municipalities or the county as to what the remedies would be to correct that capacity if it went forward to this site plan process. And they did not say how much it would cost. And it may be, so once you've set that density at this amendment stage, it's too late to change that amendment, that plan. The density has been set. So the site plan has to be consistent with these other regulations, but the property has already been designated as to what those minimum regulations are going to be. So this is the time when you have to look at this, and you have to look, and especially in a situation where you had 100 people that are resident in this area plead with the county not to move forward with this development, with this intensity. And we're not saying that there can't be development on this property. Please understand that. We are saying, we're realistic. We understand that there's going to be development, but all of these neighborhoods and our client's apartment complex all spill out onto Fort Clark. They all use these schools, and you've got to do it right. You've got to come in and do what the comp plan says. It has the status of law. I noticed that they say the burden is on us. The burden was on us to prove they didn't comply with the plan. They did not comply with the plan. Once that occurred, we had carried our burden. Once they conceded there was not capacity, and once they conceded that they did not require the applicant to submit a professionally accepted traffic analysis, you end the story. And as to compatibility and the testimony for just briefly, their experts talked about a higher density. It did not compare it with the medium high. And the other developments that are in Alachua are all medium. I see that my time is up, Your Honors. We would urge you to please find this the plan not in compliance, so that they do not make these mistakes now that cannot be corrected. It will be too late at the site plan stage. It should be sent back for them to do it correctly. Thank you, Your Honors.
Thank you all for your oral argument. Being that this is the only OA we have for this Zoom session, we are adjourned.
Thank you.
Your Honors.